Today, California Penal Code 1054 and 1054-1, and this pertains to discovery. It's Chapter 10, pertains to discovery. And where this is important is what we're saying is we don't care about the notice to appear. We want to be prosecuted by the district attorney as required by law, the people of the state of California versus et cetera, et cetera, et cetera. And what we do with this is we file a motion, put on notice that we want all the discovery from the district attorney. So by them not providing this, we can say they're not prosecuting us, thereby have it removed. So 1054 says purpose. This chapter shall be interpreted to give the effect of the following purposes. A, to promote the ascertainment of truth in trials by requiring timely pretrial discovery. B, to save court time by requiring the discovery be conducted informally between and among the parties before judicial enforcement is requested. C, to save court time in trial and avoid the necessity for frequent interruptions and postponements. D, to protect victims and witnesses from danger, harassment, and undue delay of the proceedings. E, to provide that no discovery shall occur in criminal cases except as provided by this chapter, other express statutory provisions, or as mandated by the Constitution of the United States. What's important about the next one is 1054I, prosecuting attorney, disclosure of materials to the defendant. And we have forms on our site that actually puts them on notice that they have to provide this. So 1054-1, the prosecuting attorney shall disclose to the defendant or his or her attorney all the following materials and information if it is in the possession of the prosecuting attorney, or if the prosecuting attorney knows it to be in the possession of investigating agencies. So the names, addresses, and persons that the prosecutor intends to call as witnesses at trial, statements of all defendants, all relevant real evidence seized or obtained as a part of the investigation of the offense charged, the existence of a felony conviction of any material witnesses whose credibility is likely to be critical in the outcome of the trial. E, any exculpatory evidence. F, relevant written and recorded statements of witnesses or reports or statements of witnesses whom the prosecutor intends to call at trial, including any reports or statements of experts made by the conjunction with the case, including the results of physical and mental examination, scientific tests, experiments, of comparisons with the prosecutor intends to offer as evidence at the trial. So all that gobbledygook means is if they're going to prosecute you, we're taking it away from the officer and calling in a district attorney who has to provide the officer's notes, records, copy of the citation, anything he wrote on the front or the back of the ticket, because they always write their notes on the ticket because they can't remember, they give out too many of them. And I've never had one where the DA actually presented it. I've gotten letters back where the DA says, we don't do this for traffic. And I have a letter that responds to that. We also have special requests that pertain to red light camera tickets, pacing tickets, laser or radar tickets that throw in a bunch of stuff that they have to provide, and they've never done it. So you can get your ticket dismissed by this. If you want to know what this means or understand how you're supposed to use it, or how to put it together in a defense or an attack against the prosecution, you got to go to our site, CaliforniaTicketBusters.com, and learn the secrets on how to put this recipe together for a surefire win.